Hello, outdoor industry law students. This is video, I guess I'll call it number 3 for session 3, dealing with chapter 5, the law. And believe it or not, we're going to cover all the law in this session. Obviously, we'll be looking at the law throughout this, outdoor industry law throughout this course, and this is simply an introduction to basically 4 areas of law. One is torts, negligence and intentional torts. The other is products liability, strict liability in tort, and also breach of warranty. And then a brief discussion about agency law, in particular, when principals, businesses, organizations are liable for the acts of either their employees or their independent contractors. So let's get started first with a brief discussion of the introduction to torts and negligence. So I'm going to share my screen and we'll get into introduction. All right. All right, introduction to torts and negligence. I'm going to do the best I can not to just read the slides. You don't need me to do that. Definition of torts, it's a civil claim if a party is wronged. Basic, and I always say start with what the ethical or the moral underpinning of a particular substantive area of law is. In torts, the concept is that we are all free, or we have a right to be free from unreasonable risk of harm. And when a person violates that duty to us, then we are entitled to compensation for that, and we can bring a civil lawsuit to receive compensatory damages, and if the tort is willful, wanton, or intentional, also seek punitive damages. So with that, here are the basic principles and objectives: to compensate, to place the cost where it should be, and to prevent future harms. In general, a tort occurs, first of all, when the party has a duty to the other party. We'll talk about that more. When that duty is breached, and that breach approximately causes the injury for which the party is seeking compensation. All right, so how do you determine negligence? Negligence is determined by when conduct falls below the standard set by law. And here is, for negligence, you have basically the same requirements: duty, breach, factual cause, we'll talk about that, harm, and then proximate cause. So how do we determine whether a party has acted negligently? In general, the standard is what we call the reasonable prudent person test, and this is a fictitious person that acts reasonably under all circumstances. So when conduct falls below what a reasonably prudent person would do, then the law may find that that person's conduct is negligent, and therefore the injuries proximately caused by that negligence are subject to compensation. This just indicates that when looking at the reasonably prudent person, you also look at whether the person who has committed the alleged negligence is a child, a party with a physical disability, and this is the one that's going to apply quite regularly to the outdoor industry, is if that person has superior skill or knowledge. So if you are a fishing guide or a mountain climbing guide and you're accused of some negligent conduct, the reasonably prudent person test is going to be what a reasonably prudent fishing guide or mountain climbing guide would be. So we're going to have a heightened standard of review in terms of what the reasonably prudent person standard would be. There is a concept that in evaluating the circumstances, you can take into account emergencies, but again, that is not something to be relied upon, because basically, especially in the outdoor industry, you as a skilled professional in the industry would arguably be prepared for those emergencies. So another way that we establish what would be the standard of care that a party would be required to meet is if the conduct violates a particular statute or a rule and regulation by an agency that regulates your business, then the courts and the law doesn't have to look at what a reasonably prudent person would do. They simply look to see if the party violated the standard of care as set forth in the applicable statute or regulation. I think we've got a book. One example of negligence per se in the book is the Straw versus Aquatic Adventures Management Group case, and in that case, the issue in part was whether the release covered the particular negligence, and then whether the party, the defendant in this case, whether they actually lived up to the requirements under the Florida statute regarding instruction for the use of the jet ski that was rented. So in any event, look at that case to give you a good idea of negligence per se. As indicated by the author there, a release may not be effective to release negligence per se claims. So the key is to make sure that you're aware of all of the statutes and regulations that govern your industry. First of all, you have to have a duty. Is there a duty to act? And believe it or not, generally, the law does not require a person to come to the aid of another in peril unless there's a special relationship between the parties. And certainly in the outdoor industry, that is going to apply, that the customers and guests and the outfitter, the guide, what have you, will have that special relationship where it is a duty for the guide and the outfitter, for example, to protect their customers from unreasonable risk of harm and to keep them from finding themselves in peril or aid them once they are in peril. So in other words, there is a special relationship, obviously, in the outdoor industry in those instances. Duty to act. If a party does act, decides to come to the aid of another, they must act in a reasonable fashion, not to make matters worse. And the law is gradually moving, arguably, away from this position and indicating that you can't, party, even though they may not have a duty to act, if somebody is in peril, they cannot prevent someone else from helping. Again, just to make sure I'm being clear, and I'm not sure I was, when we talk about this duty to aid another in peril, the outdoor industry, and in particular when you're providing services for customers, we in the outdoor industry are going to have a duty to come not only to protect the guests from unreasonable risk of harm and peril, but if they are in peril, to come to their aid. It seems kind of obvious. There's another duty to act even outside of the special relationship. If, for instance, a party is driving a vehicle and with not even negligently, but gets into a car accident with that party and it's not their fault, the fact that there was a accident and say somebody is lying on the road, it would be incumbent on the party that was involved with the accident or caused the injury, even though it may not have been negligence or tortious, has to exercise a reasonable care to minimize any continuing harm. All right, so let's think a little bit about what are the outdoor industry's liability for persons that are on their premises. First of all, let's start at the lowest duty. One would be, what's the duty that we would have to trespassers? And it's basically not to injure intentionally, not to intentionally injure the trespasser. Arguably, you would want to make sure that if you knew there was trespassing going on, that you would try to make the premises safe from that type of trespass. But generally, the rule is not to intentionally injure a trespasser because they're not supposed to be there anyway. Duty to licensees, those are social guests, and there we have a duty to warn persons of dangerous conditions that might cause a risk of harm to our guests that they're unlikely to discover. In other words, warn your guests that that step may be slick, that it's going to be difficult to get maneuver a part of your property or something like that. So again, just advising them and warning them about some conditions they may not observe or know about. And here's where we're going to fall most of the time in our businesses and our organizations is they're people that are on our premises are legally called invitees, and there we're required to exercise reasonable care to protect invitees against dangerous conditions that we know or should have known about. And that's the key component there. That requires inspection. It requires looking to our premises for any risk of harm that we should know about. So we obviously have to inspect constantly and that sort of thing. So in Colorado, we have a Premises Liability Act, which outlines, and it's in your pickup folder, I can show you here in a minute. It actually sets forth these same duties in a statutory form adopted by Colorado. So here's a summary of what we just went through. Now, the second issue is the negligence has to cause the harm, just a but-for test. If it wasn't for the negligent conduct, there would be no harm. So I'll use an example. It's a little outside of the outdoor industry. Let's say you constructed a building and the building didn't have a fire escape. Okay, that could be negligence. Could be negligence per se for violating a required building and use requirement. So, and let's say that somebody is in bed in that building smoking and falls asleep and unfortunately burns themselves and dies in bed. The owner or builder who built the building without putting a fire escape in was negligent. But was that negligence the cause, factual cause, for the but-for cause, the person dying in their bed having been smoking in bed? And the answer is no. They don't have anything to do with one another. So I think the book uses an example about a guide who is taking some people on a hike and arguably negligently gets them too close to the cliff. And so that's the negligence act. But what happens is I think a child just slips and scrapes their knee. Okay, the guide was negligent in maybe getting them too close to the cliff, but that negligence has nothing to do with the child slipping and hurting their knee. So there's no factual connection between the negligence and the injury. That's the first thing you have to establish is, yes, the negligence was a factual cause. And then the law gives us a break. And that break is that that the injury or liability is limited to those harms that are reasonably foreseeable to result from the negligent or tortious conduct. So again, while the guide would not be liable for the scraped knee because the negligence didn't cause the injury, and the negligence the liability that the guide should have foreseen as a result of their negligence was that they got too close to the cliff and somebody would fall off the cliff. So the liability would be for somebody falling off the cliff. So it's limited to those risks that are reasonably foreseeable as it relates to the negligent conduct. It's not simply all actions that occur as a result of the negligence or all injuries. So let me give you another example outside of the outdoor industry law area. If, let's say that you're driving a vehicle and you rear end somebody and there are people right on the sidewalk, right? And as a result of that accident, some debris hits some of those people on the sidewalk. It would be reasonably foreseeable that your negligence in driving and hitting a car, which resulted in hitting a car, might result in some of that debris hitting somebody on the sidewalk. So that would be injury for which you would be liable. But let's alter the facts a little bit. Let's say you're driving negligently, you hit a vehicle, and the vehicle happens to have in the trunk propane tanks, and you hit the vehicle, boom, propane tanks go off, blows up and blows windows out 2 blocks away from the place of the accident, and the glass breaks and slices somebody up who's in the building. There, the law would not hold you liable for the injuries by the person who was sliced up by that glass. Even though if you go to the test of the you go to the test, the factual cause, the but-for test, but for you hitting that vehicle from behind, that person would not have been hurt. In other words, you did factually cause that injury because you hit the car that had propane in it. But the proximate liability, again, stops the claim for damages to only those injuries that are foreseeable as it relates to the negligence. So you wouldn't foresee when you're driving negligently that you're going to blow out windows 2 blocks away. You would foresee that if you're driving negligently, you hit somebody, that somebody on the sidewalk may be hurt. So that's another example of this concept of limiting liability to those harms that are reasonably foreseeable as it relates to the negligent act. Okay, what are some defenses to negligence? One, there's 3: contributory negligence. This is a theory that if the plaintiff, the party that's bringing the action for negligent conduct, was at all negligent themselves in causing the injury, they would get nothing. I think there's only 3 states now that follow that. So the other is what we call comparative negligence, which is that the award for the negligent conduct, let's say that you're negligent in guiding a hike and somebody does fall off the cliff and is hurt, then if that person was somehow also comparatively negligent, in other words, running or doing something that's beyond your control, and that the jury finds that the plaintiff was also negligent, then the amount of the award gets reduced by the percentage of negligence attributable to that conduct. Modified comparative negligence, which is what most states have, and Colorado has as well, is that the plaintiffs would, in that case, if they're 50% or more negligent, the person that brings the action, then they would recover nothing. So that's the only difference between comparative negligence and modified comparative negligence. Is in a comparative negligence state, even if the plaintiff was party that brought the action was 80% negligence, they could still recover 20% of whatever the award is. In a modified comparative negligence state, if the party that's complaining is as negligent or more negligent, in other words, 50% or more negligent, then they would cover nothing. And the jury is the party that makes the determination. If you have a jury trial and not a trial to the court, and where the jury's finding the facts, then if the jury finds that the percentage of negligence is greater than, or 50% or greater, then there'd be no recovery. Assumption of the risk, we'll talk a lot more about that, and we have in release language, but it's a contractual theory that a party has assumed the risk based on a enforceable release. It's a contract theory. All right, so that is it for introductions to torts and negligence. So let's take a break for 1 minute.